Thank you. So my name is Laura Link. I'm an attorney with Archer and Griner. I've been here since 2009 in the Labor and Employment Department. And I'm going to talk to you today about two very significant pieces of legislation that were passed and signed by Governor Murphy within the last few months. Since I've been at this firm and I've been counseling employers on labor and employment matters, I've never seen the same look of panic as these two bills have inspired in my clients. So I think that I'll have a lot to say that's going to raise eyebrows and raise questions, and I'm going to try to answer as many questions that you have as I can. But I'll just do an overview first and then address anything that you'd like to raise. I want to start with the Paid Sick Leave Act. Because I think that this is a little bit more straightforward than the Equal Pay Act, so I think you might have more questions about that. But this is not a bill to be overlooked. It is certainly groundbreaking, and there are a lot of provisions in here that are sort of hidden and that I want to draw your attention to in addition to just the basics. So this Paid Sick Leave Act was signed by Governor Murphy in May, on May 2nd. It becomes effective in October, at the end of October, and it applies to almost every single New Jersey employer and all New Jersey employees. If you're already offering sick time, paid sick time off, you might be in compliance, but you might not. So you might have to alter your policies, and I'll talk about how. So, but before I get into the specifics, just a sort of history of how we got here. Sort of explains why the bill looks the way it does. The United States is good at a lot of things, but sick leave is not one of them. The last president that really pushed paid sick leave was President Taft, and that was 108 years ago. And he had no traction, and I guess he'd be happy now. We did pass on the federal level the Family and Medical Leave Act in 1993, but that doesn't give any employees any paid time off. It just gives employees with certain employers time off, but it's unpaid to care for themselves or a family member that has a health condition. So right now, and we've never had a federal sick leave law on the books that actually pays employees who need to take time off because they're sick or because they're caring for a family member who is sick. That started to change about 10 years ago when, frankly, counties and cities and states were sort of just completely frustrated with the failure to move on this on the federal level. So we first saw some movement in this area in San Francisco in 2007, and then Washington, D.C. They took it upon themselves to pass their own paid sick leave laws. And then the states started to follow after that. So right now we have 10 states that currently have paid sick leave laws on the bill, including the newbies of New Jersey and Maryland that just joined this year. So it looks like it's a trend that's sweeping the country since 2011. Connecticut started it off, and now we're seeing this move across the country. Before it got passed in New Jersey on a statewide level, there were several municipalities and cities that took it upon themselves to address this area. And what we had were 13 different cities and municipalities that passed their own ordinances that required employers to provide paid sick leave. And that created a very complicated situation for employers in New Jersey who have employees operating throughout the state. So if you had an employee who was working in Trenton, if you had another employee who was working in New Brunswick, for those particular employees, those employers would have to comply with separate rules, the ordinances in each of those towns. And God forbid you had an employee who traveled from town to town to town, you'd have to keep records of how much time they spent in each one to see what sort of benefit you had to provide to them under the respective ordinances. So honestly, it was just completely unwieldy and very difficult for employers to comply with it before the state law was passed. So what happened? So honestly, in large part to the fact that employers were tired of dealing with juggling all the different rules in all the different cities and municipalities. A lot of employers actually got on board with some sort of statewide legislation because at least then they knew there were one set of rules and that was the rules that they were going to follow. So this took a while. There have been bills that have been introduced on this topic since 2010. Governor Christie certainly was not in the camp of wanting to push for this, and he actively opposed it. He straight out said in a town hall meeting that he didn't believe that this was a good thing. So it got no traction under Governor Christie. Of course, that changed completely with Governor Murphy taking office. So on May 2nd, Governor Murphy, in accordance with some promises that he made on the campaign trail, signed into law an act concerning sick leave, okay? And it's effective 180 days from when it was signed, like I said, to just before Halloween, October 29th. And I'll tell you what this law is going to look like. So the first question is, does this law apply? Who does it apply to? Does it apply to you? Here's my handy flow chart for seeing if it applies to you. Do you employ employees in New Jersey? Yes, it applies to you. It applies to everybody. Everyone who employs anyone in New Jersey, the law applies to you. That joke works better in person. You're just going to have to imagine a very energetic Italian woman on the other end of your phone waving her hands about. So anyway, the only exception as far as employers are concerned is this does not apply to public employers who are already required to provide sick leave with full pay by law. Okay, everybody else, all other employers operating in New Jersey, it applies to. There are only two exceptions with regard to categories of employees that it does not apply to. The first is construction industry employees that are working under a collective bargaining agreement. The law does not apply to construction workers who are operating under a collective bargaining agreement, obviously because construction workers don't get sick. The other exception is per diem healthcare employees. Okay, these are nurses working on a per diem basis in hospitals, essentially. The law does not apply to them either. So public employers are out. Construction workers under a collective bargaining agreement are out. Per diem healthcare workers are out. Other than that, the only exception is any employee who is under a collective bargaining agreement as of the date that this law becomes effective on October 29th. The law is not going to apply to those union members until that collective bargaining agreement expires. Okay. For everyone else, you got to know what the law is. So what happened to all those cities' laws that we had in Paterson and Trenton and Atlantic City and Newark? The good thing about this law is that it voids all of those laws. So now employers only need to learn one law and comply with just one law. And this law specifically has a provision in there that says that local governments can no longer pass any new paid sick leave laws. So you can't have a situation where Atlantic City can step in and say, you know what, we want to be more generous than the state is being and pass their own law. They can't do that. This is the law, and everybody else is preempted from acting in this space. I just got a question that said, is there guidance as to what per diem healthcare worker means? There absolutely is. There's a definition that's in the bill. I'm not going to spend a lot of time on it because I'm sure there's a lot of people that it doesn't apply to, but basically what it says is a healthcare employee is an individual, a healthcare professional that's licensed in the state of New Jersey and employed by a healthcare facility that's licensed by the Department of Health. So it specifically carves out per any individual that's a homemaker or home health aide. So it's not people who are reporting to individuals' homes to provide them with health care services. It's more so people that are working in hospitals. But there's a pretty lengthy definition, and I'm happy to send that to any individual who would like more information on that particular topic. Okay, so Just tell me what we get. All right, now we know it applies to most of us. What is it? What does the law require? Okay, so the law requires that employers allow employees to accrue 1 hour of paid sick time for every 30 hours that they work. So you either do it on an accrual basis, or the law says that employers can give employees what it terms the quote-unquote full complement of sick time at the start of the benefit year. So you can either allow employees to accrue it as they go, as they work, right, 1 hour for every 30 hours, or you can just give it to them right up front. And there's a maximum of 40 hours in any benefit year that your employers are going to be able to accrue and use. So what is the benefit year? Employers get to define that. It could be the calendar year, it could be your fiscal year, it can be whatever you want, but you have to define it, and you have to notify your employees up front what year you're going to use. And then you cannot change it easily. You can change it, but you can't just do it randomly. Once you decide, once you set it, if you want to change it, you have to provide notice to the Department of Labor of the state of New Jersey and to your employees. So it is possible to change it, but it's not easy to do. Which hours does it apply to? We don't know. And where this is going to get tricky is if you have employers who have employees who are crossing state lines. It seems like the hours that are going to count as hours worked are hours that are worked in New Jersey, okay? But there's no clear guidance on this. So if you have an employee who's working in New Jersey part of the time and in Pennsylvania part of the time, arguably you could read the law to mean that you only have to give them 1 hour of sick time for every 30 hours that they work in New Jersey, not for when they're working in Pennsylvania. And then there's an open question as to whether or not you have to allow employees to use their paid sick time for a time that they were working in Pennsylvania. So these are areas that are sort of gray right now and are going to need to be fleshed out in regulations or by the courts as we go forward. Another sort of confusing and open question is, what exactly does it mean to offer your employees the full complement up front? This is easy for full-time employees, right? Full-time employees, you would offer them up front the 40-hour maximum that they're entitled to under the law. But for part-time employees, they might not ever work enough hours to accrue the 40-hour maximum. So, for example, if you have a part-time employee who's going to log 900 hours in the year, they would accrue 1 hour for every 30 hours worked, so that would be 30 hours of leave. So for your part-time employees, there's an open question as to whether or not offering the full complement would mean offering what you estimate that complement to be depending on what you think their hours are going to be for you in that year. Again, right now this is an open question, and we're going to have to wait and see what the regulations look like that are going to come out on this. What is clear is that employees can't use more than 40 hours in any benefit year, okay? And they can't accrue more than 40 hours in a benefit year. And they can't carry over more than 40 hours in a benefit year. Now, if you really take a look at this, it's a little bit confusing because there are provisions in here that allow employees to carry over time from year to year. But regardless of how much time they carry over, they can never use more than 40 hours in any given year. So in some respects, the carryover provisions are sort of meaningless in some ways. So, for example, if you have an employee who in year 1 uses no sick time, 0 sick time, technically they could carry over their 40 hours of accrued time into the second year. So in the second year, in theory, they'd have 80 hours, or they could potentially accrue up to 80 hours, right? The 40 they carried over and 40 new ones in year 2, but they can't use 80. They can only use 40. So like I said, if you have employees that, you're not going to have a situation where you have employees who are never using sick time and are banking the time over and over and over years down the road and are going to have 300 hours or something like that. There's protections in this bill against that. The only real benefit of the carryover is that if you operate on an accrual basis, so if you don't offer the full complement up front, the carryover would basically allow employees to use their sick time earlier in the year. Okay? So if you're on a calendar year and you're on an accrual basis, so your employee's only going to earn 1 hour per 30 hours worked, by carrying it over, they're going to have more time in January than they would otherwise. Okay. So employees are never going to be permitted to use more than 40 hours in a year. As far as getting paid out for unused hours, when an employee is terminated or when they resign or retire or separated for any reason, there's nothing in this law that requires employers to pay it out unless you have a policy that says you will. So this is a time to go back and look at your handbooks and see what it says as far as paying out sick leave at separation. And I'll caution you that if you don't have anything on the books, but you have a practice of doing that for your previous employees, it could be argued that you have a policy, albeit an informal one, of paying out employees for that time. So if you don't want to pay out employees upon separation for any unused but accrued sick time, you want to make that crystal clear in a written policy. Okay. So the law, like I said, is effective October 29th. Employees who are current employees are going to begin accruing the time as of October 29th, okay? They can use that time as soon as they accrue it. Employees who are hired after October 29th are going to start accruing it the day that they're hired. They can't use it for 120 days. Okay, there's a 120-day waiting period between when the employees are hired and when they can start actually using it, but it accrues during that time. Sorry, I see some questions coming in. I'm going to try to answer them as I go, but I might hold until the end. But as far as one question I just got is, how does this work with PTO time? I'm going to get to that in just a minute. Okay, so another thing is, question I'm getting from employers is, do we have to buy out unused sick time at the end of the year? The answer is no. You don't have to buy it out, but you have the option to do so. And it depends, your options depend on whether or not you're following the full complement upfront system or you're following the accrual system. So if you offer employees the full complement of sick time up front at the beginning of the benefit year, you have the option of paying those employees for their unused accrued sick time at the end of the year or allowing that sick time to be carried over. That's completely in the employer's discretion what they want to do. Frankly, I don't know why you wouldn't allow them to carry it over unless you just want to be a generous employer, because they're never going to be able to use more than 40 in a given year anyway. If you follow the accrual method, so you don't give them the full amount up front, but they accrue it on 1 hour per 30 hours worked, then you can buy the time out if the employee agrees. The employee has to agree to it. Okay, and you can offer to either buy out all of the unused time at the end of the year, or you can offer to buy out 50% of the unused time. I don't know why they picked 50%, but it can't be 45%, it can't be 60%. It's either you buy out half, or you buy out all, or you don't buy it out. If the employee agrees, that's fine, you can do that. If the employee says no, then their unused time carries over. Again, this is up to you as to whether or not you want to offer to do the buyout or not. You don't have to, but if you don't, you have to let them carry the time over. If you want to pursue the buyout option, you have to do it in the last month of the benefit year. Okay, so if you run on the calendar year, you have to do this in December where you make this offer to your employees, and they have 10 calendar days to accept or reject your offer. If they accept your offer and you do buy the timeout, you have to pay it out at the employee's normal hourly rate. Okay, you can't do it at a discounted rate. It's got to be the normal hourly rate that they're earning at the time that you buy them out. Okay, what reasons can you use the sick time for? So the reason that this is much broader, this law, than just giving your employees time off for when they're sick. Okay, there's a number of reasons that you have to allow your employees to use this time. I just got a note that says phone audio has been lost. Can somebody confirm that you can hear me?
Hi, Laura. We can hear you perfectly clear.
Okay, thanks. I'm going to keep going then. Sorry. I appreciate all your quick responses. Okay, so for the reasons that you can use the sick time, of course, if the employee's sick, if they need to take time off to get diagnosis, a treatment, some sort of treatment, recovery, go to the doctor, preventative care appointments, etc., that's a reason that an employee can use this time. If a family member is sick, an employee can also use this time to care for their family member. An additional reason is if the employee or a family member is the victim of some type of domestic violence. There are also situations then when you allow your employees to use this paid benefit. So you have to allow employees who are victims of domestic violence to get medical attention associated with that domestic violence, to pursue counseling, to go to court or legal proceedings, to relocate if they need to. Anything in connection with the domestic violence incident, basically, you have to allow your employees this benefit during that time period. Another time is when a workplace or a school or a daycare of your employees' children is closed for public health reasons. Okay, not for a snow day, but because there's some sort of outbreak of some sort of epidemic or outbreak. Let's just hope that doesn't happen. Also, if a public agency determines that an employee's presence would jeopardize public health, right? Somebody has SARS or something terrible that we don't want them to come into work with, you have to allow them to have this time off. Let's also hope that that's not the case. Another example is if you have to allow employees time off to attend school-related conferences if required or just requested by the school to discuss a child's health issues or disability issues. Okay, so if you have an employee who has a child that suffers from ADHD and they need to go to a meeting at the school to discuss putting them on a IEP or something like that, that would be covered as a reason that they could use their paid sick leave time for those hours. Okay, who are the family members? It's pretty broad: child, grandchild, sibling, spouse, domestic partner, civil union partner, grandparent of the employee. Those are sort of standard. You see those in a lot of various laws when they define family members. What's broader here, though, is the law also says that family member includes any individual related by blood to the employee or whose close association with the employee is the equivalent of a family relationship. So there doesn't have to be a blood relationship. If somebody has someone living in their home, for example, who they treat like family and there's the equivalent of the family relationship there, even though they're not blood related, that would count. So the employee could take time off, their paid sick time off, to care for that individual. Okay, somebody asked previously, what about the fact that we already offer PTO? Does that count? Yes and no, it could. So if you are an employer that already offers vacation or personal time, or PTO is paid time off, right, or sick time already, you can count that towards complying with this law, but only if your employees are allowed to use that time for all the reasons that this law requires you to allow your employees to use this time off for. So everything that we just went through, if you already give your employees vacation, personal, and paid time off, you can count it as long as your employees can use that because they're a victim of domestic violence, to care for a sick family member, to care for themselves when they're sick, to go to their children's school when they have a disability-related issue to discuss, and so forth. Okay, so your policy has to specifically allow for that. And you can't have the same restrictions apply to this time that a lot of employers typically do for vacation and other times. So I'll give you an example. It's very common to see in vacation policies that employees have to give at least 30 days advance notice of the desire to take off the vacation time. You can't do that here. If an employee is sick and they have some sort of emergency and they need to take the time off and they can't give you 30 days notice, right? They can only call you that morning and say, I'm sick, I have to go to the doctor, I need to take time off. You have to allow them to do that, okay? So your policy is in all likelihood going to have to be revised to make it clear that if the reason for the need for the time off is something that falls within the purview of this law, then whatever sort of notice requirements you have are going to be relaxed. Okay? Some other rules that are in the law that you should be aware of: you can't force a sick employee to find a replacement. Okay, so you can't have a provision that says, sure, you can adjust your schedule, just work it out with one of your coworkers. You can't do that. You can't force somebody to do that. You can't tell them you can't take off unless you find somebody else to cover your shift. All right, that's illegal. You can come to an agreement with the employee who needs the time off, where you agree that they're going to make up the time in the same or the next pay period. You can come to that agreement, but you can't force it. It has to be truly voluntary, okay? And the employee then, in that case, keeps their sick time, so they don't burn through their sick time if they're making up the time on some other day, okay? The law also says that the employers can set time increments, right? So that you can say, if you're going to take sick time off, you have to take at least 4 hours off, or you have to take at least 6 or 7 or 8 hours, whatever. But that number that you select cannot be more than the number of hours in the employee's shift. Okay, so if an employee works a 7-hour shift, you can't set the increment at 8 hours. All right. Okay, so I talked a little bit about notice, and I just want to circle back on that. What this law says as far as notice is if a leave is foreseeable, you can require an employee to give 7 days advance notice of the need for leave. So, for example, if it's going to be their annual physical and they know the date 7 days in advance, you can require them to give you the 7 days notice. If it's a court hearing in connection with a domestic violence incident, you can require them to give you the 7 days notice. But the law says that if it's not foreseeable, if somebody just wakes up with the flu, then you can only require the employee to give as much notice as practicable. You can require doctor's notes if an employee takes off 3 consecutive days of absence under this law. Okay, so if you have an employee that's out for 3 days, that's fine. You can ask for a doctor's note. You can also ask for a doctor's note for foreseeable leave. So if someone says, I'm going to have an appointment on, July 30th, you can say, okay, give me a doctor's note, bring it back when you come back. There's nothing in this law that addresses whether or not an employer can challenge the legitimacy of a doctor's note. That's an open question as to what that process can look like. So if you're in HR or you're an employer, I'm sure at some point you might have had the fortune, I suppose, of dealing with somebody who you think is faking it, or who has a friend or a family member who's a doctor, and somehow manages to come up with doctor's notes every Friday indicating that they had some terrible illness that day. And then you see on Facebook that they went to a U2 concert that night. The law is just not clear as to whether or not you can challenge that. But I'll tell you, otherwise, under New Jersey law, you typically can send your employees to your own doctor to have them evaluated. There's a record-keeping requirement in this law that's pretty onerous. You have to keep employers have to keep records of time accrued, sick time accrued, and time used for 5 years. 5 years. And that's a very long time, and it's also the penalties for not doing so are pretty terrible. If a complaint is lodged against an employer that says that this law was violated, right, that the employer did not give an employee the sick time that they should have given them, and the employer does not have that documentation that they're required to keep, this law treats that as a presumed violation of the law, right? The employer is presumed to be guilty unless they can show otherwise by what's called clear and convincing evidence. Okay, that's a pretty high standard, clear and convincing evidence. So it's very important to keep good records of sick time that's accrued and sick time that's used, and to hold on to that for 5 years. The law has specific carve-outs which indicate that retaliation is prohibited, so you can't retaliate against an employee who seeks, to use the benefits of this law, who seeks to use paid sick time. You can't retaliate against them. You can't terminate or discipline an employee for using paid sick leave. And if you do, the penalties are the same as they are for any violation of a wage and hour law, which means back pay. So if you terminate an employee unlawfully because they used paid sick leave, you would owe them pay for the entire period of time that they were out of work while you litigated that case. And then also attorney's fees. You would have to pay the other side's attorney's fees that they incurred in bringing that lawsuit against you. And there are also penalties provided under New Jersey wage and hour law, which are typically a percentage of whatever it was that you owed that employee and didn't pay to that employee. And that's discretionary and could be as much as 25%. Okay. In connection with the anti-retaliation provisions, there's some very critical language in this law that says that there will be a rebuttable presumption, right? So an assumption that an employer has violated the law if an employer takes any sort of adverse action against an employee. So demotes them, terminates them, docks their pay. If they do anything that's adverse to an employee within 90 days of an employee filing a formal complaint pursuant to this law, talking to anybody about an employer's alleged violation of this law, whether they are right or not. If they are just talking to someone and they have a good faith belief that the employer has violated this, that would fall into this category. If the employee cooperates with any complaint under this law or opposes any unlawful employer act, right? If an employee goes to an employer and says, I think you're violating the paid sick leave law, and here's why. Or if an employee informs any person of his or her rights under the law. So someone goes to the boss and says, you have to give me this paid sick leave now that this new law is in place. Okay, if any of these things happen and an employer takes an adverse action against that employee within 90 days of that thing happening, there is going to be a presumption that the employer has violated the law unless they can show otherwise. So what do you do? First of all, if you're a unionized workforce, you want to look at your collective bargaining agreements and find out when the expiration dates are going to be. Because like I said earlier, this law doesn't apply to members under an existing collective bargaining agreement. It's going to apply as soon as that collective bargaining agreement expires. And the only time that an employee can waive their rights under this law is if they do so in a negotiated collective bargaining agreement. That's the only way that employees are permitted, or that the law allows employees to waive their rights under this law. So this is definitely a topic that needs to be addressed in your negotiations if you have a unionized workforce. The next thing to do is look at your employee handbooks. You want to make sure that you lay out what the procedure is going to be, whether or not you're going to do this on the accrual basis, whether you're going to do it on the full complement basis. If you have part-time employees, how are you going to come up with that full complement number? Okay, like I said, we have a lack of guidance in this area, but if you lay out in your policy something that makes sense and doesn't look like any part-time employees are going to get skimped at the end of the year, or maybe if you have a system where you give them a certain amount of time up the year, let's say 30 hours at the beginning of the year, and then should it turn out that you made a mistake and the employee works more than 900 hours, if you correct that at the end of the year, that might be a system to do it by. But you need to lay out what you're going to do and how you're going to do it and why it makes sense in your policy. If you want to try to just come into compliance with the law by applying your vacation and your PTO policies that you already have more broadly, you got to go back and look at your policies, see what it says as far as what the permissible reasons are for using vacation and PTO, and make sure you broaden it to include the reasons that are in this law. And you also want to go back to those policies and see what the notice requirements are, and again, make sure that they're compliant with this law, which is 7 days for a foreseeable reason, and as soon as practical for a reason that's not foreseeable. Okay, I'm gonna start talking about the Equal Pay Act, but before I do, I just want to answer a couple of the questions that came in. So the first question is, do we start accruing after 90 days of employment? The answer is no. You start accruing immediately, but you can't use it until after your first 120 days of employment. Okay, the next question is, the max 40 hours, does that apply to both part-time and full-time? The answer, yes, the maximum does apply, but if you're a part-time employee, you might never reach that. It depends on how many hours you're logging. So remember, what you have to do is give at least 1 hour per every 30 hours that are worked. So it just depends on how many hours your part-time people are working to see if you're ever going to hit that 40. But yes, that would be the maximum, 40, no matter how many. How does this work with PTO time? The question is, we give our employees 8 PTO days. Do we have to carry over that time? Yeah, so if you have a pretty generous paid time off policy, like I said, you can use that to contribute to the 40 hours that you're required to give, as long as you're fully complying with this law. And what that means is, as long as you're giving them enough time, right? So the equivalent of at least 1 hour per every 30 hours worked, as long as you're letting them use it for all the reasons that they're allowed to use it under this law, as long as you're not making them comply with more burdensome notice requirements in this law provides, and as long as you're following the carryover policies. Now, that's going to this is where it's going to get tricky if you're trying to use your PTO towards complying with this law, because if you currently have a PTO policy that says under no circumstances can you carry this time over, well, that's not compliant. Okay, you have to let employees carry over the time unless they agree to you buying them out. Okay. So you'd have to go back and look at the specifics and make sure that you're in complete compliance. And honestly, the easier approach might just be splitting up your paid time off policy to separate vacation, sick, and potentially personal time policies. Okay, I'm going to jump into the next topic just so that we don't run out of time. And there's a lot I want to say about the Equal Pay Act, but I'll try to circle back on some other of these if we have time at the end. So, okay, the Equal Pay Act. This has been coined the strongest Equal Pay Act in America. This bill, frankly, is crazy. This law, I should say. I'm going to show my hand. I am a female. I want to be paid. the same that everybody else is being paid for the work that I do. I think that I am pretty liberal, but this bill is crazy, and I'm going to tell you why. And frankly, I don't know how employers are going to be able to comply with this. This is a bill that started off with very good intentions, but I'm not sure anybody read it that signed it. So it was signed on April 24th by Governor Murphy. This is an amendment to the existing New Jersey law against discrimination. Okay, it becomes effective in just a few days on July 1st, which is a very short turnaround, especially when you consider how unbelievably expansive this law is. It's very difficult for employers to comply with this, and it's just going to be a whirlwind of litigation that comes out of this. But let me get into some of the specifics. So first of all, again, this was passed by an overwhelming majority of the legislature. It's named after Diane B. Allen, who's a Republican that was in office for 30 years in New Jersey. The Assembly voted for it 35-0. Okay, 5 abstained, but 35-0. In the Senate, it was 74-2. So there really was no opposition against this bill. But if you're a labor and employment attorney, and it doesn't matter what side you're on, plaintiffs or defense, there's just a lot in this bill that it doesn't make any sense and is incredibly vague, and I think all of the lawyers in this area agree that this is a doozy, to say the least. So let me get into the specifics. All right, first of all, who does this apply to? All businesses, okay? New Jersey law against discrimination applies to all employers that are operating in New Jersey that has an employee. So we're really talking about everyone. We're talking about both the public sector and the private sector, okay? Unlike prior versions of this bill, and unlike other bills that you've heard about on the news and across the country, this is not a gender equity pay bill, okay? It does not just apply to gender-based differences in pay. This bill applies to any employee in any classification that's protected under the New Jersey law against discrimination. Okay, so that's why it's called the Equal Pay Act, and not the gender. The word gender or sex aren't in there because it's much, much broader than that. So under the New Jersey law against discrimination, what you see on your screen here is a list of all the protected classes. Okay, these are the classes of people that are protected from discrimination under this law, and you'll see it's numerous: race, creed, color, national origin, nationality, ancestry, age, marital status, civil union status, sexual orientation, being in the armed services, sex, pregnancy, genetic information, having a hereditary, cellular, or blood trait, right? So it's pretty expansive. Any individual in any one of these protected classes could bring a claim under this new Equal Pay Act. Okay, so if you can think of an employee that doesn't fit into one of those protected classes, I feel sorry for that guy, and I want to meet him. No, honestly, everybody's going to fit into some protected classification, so this really does cover just about everybody. And what the law says is it is now illegal for an employer to pay any of its employees who is a member of a protected class at a rate of compensation, which includes both salary, wages, and benefits, which is less than a rate paid to employees who are not members of that protected class. Okay? If you pay, obviously, women one rate and you pay men that are doing the same work more money, you violated this law. That's the easy example, but it's going to be much broader than that. And the other thing about this law is, we've all heard the term equal pay for equal work. This law is broader than that. This law says there can't be any pay discrepancies for two individuals who are performing substantially similar work. And what the law says is when viewed as a composite of skill, effort, and responsibility. So it's not equal pay for equal work What this law says is substantially similar work. Okay, we don't know what that means. But this is broader than just equal pay for equal work. And the considerations that they're going to look at are going to be what is the skill, what is the effort, and what is the responsibility related to this position. Okay, so what are you looking at? You're looking at how much do you pay employees in a protected class, and you're comparing it with how much you're paying employees in any other protected class or in no protected class. Okay, so employers can't get out of this by saying, well, all of my employees are in a protected class, so it doesn't matter. Not true. So if you can't pay, individuals that are performing substantially similar work, you can't pay Hispanic individuals more than women. You can't pay women more than people with disabilities. You can't pay, right? So all the protected classes are at play here, and what you're comparing are the employee at issue, what protected class they're in, with everybody else that's not in that particular class. The million-dollar question is here, what is substantially similar work? We don't know, and the bill doesn't have a definition. So we know that there was a reason that the legislature chose to use that term instead of equal work, but we don't know what it means, and this is going to be filled out by the courts, by juries, looking at what is the skill and the effort and the responsibility involved and measuring them. But it might not be the same title. It might not be, it could be in different locations. We just don't know what this is just yet. What's really critical and crazy about this bill, or about this law, is that it flips the burden of proof for discriminatory pay claims. So it is Law 101 in this country that if somebody sues somebody else, they have the burden of proof to show that, in fact, they are the victim of a legal violation. That's not true here. Okay, this law flips the burden to the employer, and the employer has to actively prove that they did not violate the statute, that if there is any sort of pay differential, that it is based on entirely lawful reasons. Okay, so if there is any pay discrepancy, there is a presumption of guilt, and the employer only gets out of it if they can prove that that pay discrepancy is based on legitimate factors. Okay, so what are those legitimate factors? There's 3 ways to escape liability for employers if a pay discrepancy exists. The first is if they can show that the difference in pay is due to a seniority system. Seniority system is not defined in the law. Typically, it's what you see in union contracts, but it doesn't necessarily just mean years of service. So just because I've been doing my job for 10 years and somebody else has been doing it for 18 years, that's not it, right? It has to be some sort of system, which to me would mean it's in a contract or it's in some sort of policy, okay? The second exception would be if the pay discrepancy was based on a merit system. Again, this is not defined by the law. We don't know what that means, but we know that they use the term system, which suggests that it can't just be merit-based, but there has to actually be some sort of compensation policy or guidelines or some sort of system that's laid out that an employer can point to and say, this is the system, the equation that we use to come out with these differences, these different compensation scales. Okay, and then the third exception is a multi-pronged test. You have to meet 5 factors, okay, and this is the third exception. If an employer can prove that the pay discrepancy is based on what's called a legitimate bona fide factor, such as training, education or experience, or the quantity or quality of production. Okay, that's the first prong. We're going to talk about 4 more. But if you can prove that it's because of that, because you have a guy whose job is to make furniture and he produced 10 couches at the end of the week and the other guy only produced 5 couches, fine. That's based on quantity, and you could pay the more productive employee more, right, presumably under this. But it has to be a legitimate bona fide factor based on training, education, or experience, or quantity or quality of production. But we still got to meet the next 4 tests. That factor, whatever it is, cannot perpetuate pay discrepancies based on any characteristic of members of a protected class. So even if you don't intend it to have the effect of it being that women get paid less than men, for example, if whatever factors you're considering perpetuate that, right? If the outcome still is that members of a protected class are being paid less than members who aren't in that protected class, then you don't meet this test. So I can see this coming up where if it's true that you have a certain class of employees that are more likely to have higher levels of education than other classes of employees, if you consider that as a factor, it might have the impact of disproportionately affecting minorities, for example. And that wouldn't pass muster under this test. The third factor is each of the factors has to be applied reasonably. They don't tell us what that means, but I think it's fair to say fairly, okay? The fourth one is one or more of the factors has to account for the entire wage differential. You have to be able to explain the whole thing. If you're paying one person $70,000, another person $80,000, you can't say, well, 7 of that, 7,000 is attributable to this, and the other 3, we don't know. We just really wanted to bring the person in. You have to be able to explain the entire difference on one of these factors. And the fifth factor is that the factors that you're considering have to truly be job-related and based on a legitimate business necessity. Okay? So, for example, you can't pay somebody more because they have a master's in making pottery if you're hiring them as an accountant. Okay? Because that's not job-related. So you have to really show that whatever it is that you're considering, you can't just come up with fake criteria to elevate somebody on the pay scale. It has to be factors that truly are related to whatever it is that the job is, right? They actually need this educational requirement. They actually need this physical requirement. They actually need this certificate and so forth in order to perform these job functions. There is specific language that says, on that last point, a factor based on business necessity shall not apply if it's demonstrated that there are alternative business practices that would serve the same purpose without producing the pay discrepancy. Holy moly. This means you might think you have really good business reasons, but if a jury can come up with another way that you could have done it short of paying this person less, basically they can second guess you and say, no, there is another way to do it other than paying them less. There is another way to do it other than considering that factor, right, is basically what it would come down to. Then, again, the pay discrepancy would be presumed to violate this law. You would not meet your burden of proof that it was justified. One thing that has my head spinning, this law specifically says that comparisons of wage rates shall be based on wage rates in all of an employer's operations or facilities. That means, to me, if you're a New Jersey employer and you're paying your people in Newark more than you're paying your people in Deptford Township, New Jersey, because the cost of living is much higher in Newark and that's what you need to pay to attract good people, this law doesn't allow you to do that. At least it's not clear. Hopefully we'll get judges that go the other way on that decision, but I would be very worried about making that decision under the way that this law is currently drafted. I have to really make the point that intent does not matter under this law. Employers do not have to be consciously discriminating against any particular protected class to be found in violation of this law. All that matters is dollars and cents. Are you paying people in a protected class less than people who are not in that protected class? If so, why? And if you can't prove that it's because of a merit system a seniority system, or some bona fide factor that actually is job-related, you are going to be found in violation of this law. Another particular provision in this bill that makes life for employers difficult is you can't fix the problem by cutting the pay of employees who you are paying too much to. So if you go back to your books and you say, you know what, there is a pay discrepancy here. We're paying this individual $80,000. They're performing substantially similar work to another person, and we're paying her $70,000. You can't fix that problem by bringing that $80,000 employee down to $70,000. You have to bring the $70,000 up to $80,000. There's a specific language in the bill that says that. I will add, though, that the bill goes into effect on July 1st, the law, and if you fix this in the next 3 days, 2 days, it won't apply. So cut pay real fast. The other thing about this bill that gives employers a headache, if I haven't told you enough already, is it extends the statute of limitations. So currently, if you have an employee that sues under the New Jersey law against discrimination because of harassment or discrimination, what have you, there's typically a 2-year period from the date that the unlawful act occurred that they can bring that claim within. Under this law, that 2-year period is extended to 6 years. Okay, so you can have employees that can go back in time and collect 6 years of higher wages that they should have been paid if they can show a discrepancy that's not based on legitimate business reasons. This law also makes it so that every single paycheck is a new violation, so that 6-year statute of limitations restarts every time you issue the paycheck, which means that there's going to be a huge look-back period, but it's not going to apply to time before the law was passed, so we're just moving forward. The law also has a pretty broad anti-retaliation provision in there. So you can't retaliate against an employee because they seek legal advice about what their rights are under this law, because they talk to an attorney about it, because they share information with the DOL or any other governmental agency about it. You can't punish your employees for discussing the terms and conditions of their employment. So you can't prohibit employees from telling each other what they make. Don't think you can get around this by saying you can't talk about your pay. This law specifically prohibits that and allows employees to discuss their rates of compensation with each other or whoever they want to, and employees cannot be required to waive that right. Okay, the last thing I want to mention is treble damages. If I haven't scared you enough already, if an employer violates this, the bill specifically provides for treble damages. That means whatever that employee should have paid, multiply it times 3. That's how much money they're going to get if they win at trial. So you're talking about a ton of money, potentially, and class actions that could be pursued. So what should you do? One thing that you can do if you're an employer and you're worried about this is consider requiring your employees to sign arbitration agreements, to go to arbitration instead of to trial. That would save you costs. You can't limit the statute of limitations, so you're kind of really stuck on that. Review your handbook and your policies. Go back and look at all your compensation practices and find out if you have any pay discrepancies and find out why and fix them and document it. And document how you're arriving at the numbers that you're arriving at. And you want to make sure going forward that everything that you're doing is clearly laid out in a matrix. So this is what we consider in coming up with compensation decisions, and have guidance documents so that you can justify any number that you arrive at on reasons that are very clearly not related to somebody's status in a protected class. Like I said, you have until July 1 to fix the problem. Good luck with that. And if not, and you get into trouble, give me a call. All right. I'm out of time, so I'm going to end there. I'm sorry I ran right up to the end of the time, but if there's specific questions anyone has or they want to shoot me an email, you can get me at llink@archerlaw.com. That's LLINK@archerlaw.com, and I'm happy to answer any questions anybody has.
Thanks, Laura. So That concludes the end of our webinar. For those of you who have not, who do not have any questions, you guys can feel free to disconnect now. We also, Laura, do have a couple of questions that I was wondering, will you be able to answer?
Yeah, sure, of course, yeah. I just didn't want to keep anybody beyond my time, but I'm happy
no,
to stay.
No, it's fine. I just wanted, for those of you who do not have anything to ask, you guys are free to disconnect. For those who'd like to have their questions answered, just hang on the line and we'll address them.
I can start pulling some of these off this list. What about different pay scales in different locations? Yeah, that's a problem. This basically, like I said, if you have employees that are in Newark and employees that are in Deptford Township, this law doesn't carve that out. You don't get to consider cost of living in making your comp decisions under this law. So that's definitely a problem. The law makes very clear that they are going to compare across locations. So that's unfortunate, but it's true. Again, hopefully the courts will change that interpretation, but right now that's what it looks like. Let me see what else we got here. Okay, if an employee uses 40 hours of paid sick leave and takes additional hours as unpaid leave, can we terminate them for excessive absences? That is a very tricky question. The answer is probably not. The Americans, first of all, it depends on how many employees you have as to whether or not the Family and Medical Leave Act applies to you. If the Family and Medical Leave Act applies, meaning you have over 50 employees, you have to give your employees at least 12 weeks off, unpaid, and you have to give them their job back when they return, assuming that it's for a legitimate health condition or to care for somebody that has a health condition and they give you doctor's notes proving that. So in that case, you certainly, 12 weeks is more than 40 hours, so you certainly would have to give them the time off. That doesn't mean you'd have to pay them, but you have to give them the time off. And the same result would obtain even if the FMLA didn't apply to you under the Americans with Disabilities Act. You sometimes have to give employees time off as a reasonable accommodation, and I can guarantee you that a court would find that giving an employee who really did have a serious health condition or has a family member who has a serious health condition, that has their own serious health condition, that you'd have to accommodate them beyond just 1 week's time off. Typically, there's no hard and fast number in the ADA, but the rule of thumb that a lot of lawyers use is it could be as much as 6 months if you have an employee with something really serious going on like cancer, for example. But that's a very fact-specific question. But no, don't think that just because an employee has exhausted their sick time that you're free to terminate them at that point. Another question, should sick time buyouts be at year end or can they be at employee anniversary date? This is going to depend on what benefit year you set. If you set a calendar year, the buyouts have to be in December. The buyouts have to be in the last month of the benefit year, but you are free to define the benefit year as the employee's, as starting and ending on the employee's anniversary date. So it would just be in the last month before the employee's anniversary date that you should do the buyouts.
Laura, would you like me to read off a couple of questions that I flagged?
Sure.
Sure. So for I guess we'll go in kind of chronological order. One person asked, do we start accruing after 90 days of employment?
No, you start accruing on day one, but you can't use it until 120 days in.
Okay. And then I believe you answered this already, but somebody asked, the max 40 hours applies to PT and FT? That's
correct.
Okay. So another one asked, how does this work with PTO time? We give our employees 8 PTO days. Do we have to carry it over?
Yeah, I actually addressed this one already.
Okay.
Yeah.
Here's one asking, we really need an example of a part-time person computation. Please, he asked to show the math for 30 hours per week for a 900-hour example, as also most part-timers have fluctuating hours, so it may be 20 hours one week, 25 another. How do you compute it throughout the year?
Yeah. So if you're using the accrual basis, as soon as they hit 30 hours, you're logging an hour of sick time that they've accrued. Whether that happens in 1 week or 2 weeks doesn't matter. So every time they hit 30, 60, 90, 120, you're adding that 1 hour to their accrual. If you choose to do the full complement method, it's going to be much trickier for part-time employees. I wouldn't recommend it unless you have a part-time employee that has a pretty set schedule and you're going to be able to estimate how many total hours they're going to work in the year, and I would overestimate it rather than underestimating it. So if you're sure that you're going to have a part-time employee who's only going to log 900 hours in a year, the full complement would be 30 because that's 1 hour for every 30 worked, right? So you can choose which way to do it, but probably the safer way to do it with part-time employees is to accrue it on an ongoing basis instead of doing the full complement method.
Okay. Also, I have somebody asking if they could have the definition of a per diem healthcare employee. I think you may have answered that.
Yeah, I'm happy to send it out. It's a little bit lengthy, so I don't want to read through the whole thing, but I'm happy to send it to anybody that wants it.
Okay. Then another one asked, we offer a 40-hour paid absent time benefit irrespective of reason a year, which is given as the full complement at the beginning of the benefit year, and the remaining not taking balance is paid at the end of the benefit year. Are we complying with sick time law?
Almost. So the questions would be, can your employees use that for any time, for any reason that this law requires them to be allowed to use it? So, for example, in the domestic violence situation, the care for a family member, et cetera, just change your policy to allow them to use it for those reasons, and you're good. The other questions I would have is, as far as paying it out at the end of the year, remember under this law, your employee has to agree to that. And if they don't agree to it, you have to allow them to carry the time over, although they can never use more than 40 in a given year. But if those things are true, and if you're not holding them to a more burdensome notice requirement than what's provided in the law, which is 7 days for foreseeable reasons and as soon as practical for any other reason, then you're fine. You're good.
Okay. Well, thank you, Laura. That's about all we have for time today. So for those of you who didn't get any of your questions asked, if you could reach out to Laura, I'm sure she would be glad to respond because we have a couple of extra questions that have popped up as well, but we don't want to hold her up for too much longer. But I'd like to thank you for coming here, Laura, and thanks for everybody who stuck around to get their questions answered.